Hello and welcome to Talking Legal episode proudly presented by Baker White Lawyers, your full service family and business law firm. I'm Praveen Gautam, your trusted marketing advisor. I help entrepreneurs and enterprises to build their digital brand and monetize it. Today's episodes, I have a Len Watt, who is a founder and principal lawyer of Baker Watt Law Solicitor. Len has extensive years, 25 years of experience in liaising with QBCC from license applications to resolutions of million-dollar building and construction disputes. And Len is a trusted law solicitor. Welcome to the show, Len. Great to have you today.
Hey, Brian, it's really nice to be here. Thank you.
Great. A lot of our viewers, in fact, if they're watching this, you're watching this right now from Facebook or YouTube or any of the medias, yeah, feel free to give a thumbs up, comments, or share this post. Today, our topic is settling your dispute. So, talking about in detail, and that's what some of our viewers are interested to know.
Sure.
Very basic questions on how to settle those disputes. So let's start with very, in a basic way. If someone is in dispute, Len, how can they settle it easily?
There's a number of different ways, I suppose. Number one, and the most obvious, is if it's a litigation, is to proceed with the litigation and have the court decide. But as a lawyer, that is probably not the best way to solve a dispute, because you take the power of being able to solve it out of your own hands and you give it to somebody else, and the court will make a decision. Whether or not you agree with that decision or not, they will still make that decision. So in some respects, the idea of settling the dispute yourself with the other party before it gets to that point can be attractive in some circumstances. So you can either another way is to by ADR, arbitration, or expert determination, or mediation, and then this joins, I suppose, or as part of mediation. Basically, you can come to an agreement with the other party. So, for example, one party to a dispute might accept that I do owe this person some money. That did happen, and make an offer on what we would call a without prejudice basis. So that means that it's not necessarily able to be used in the court matter, and it's there to encourage people, or without prejudice, is to encourage people to be frank and honest, and try and settle the matter. And so you would say, on a without prejudice basis and these conditions, I would be prepared to settle the matter for this amount. Send that to the other side and see how they respond.
Would be nice to settle people understand that, and nice that people will be settling their matters, isn't it? That would be an easy exercise, I would imagine.
It's no.
Really?
It's an extremely difficult exercise in some respects, because everybody has their point of view in relation to a dispute, and my view and my client's view are potentially different, and certainly different from the other side's view. So it's sometimes a matter of, to an extent, herding cats to get to a point where everybody is happy. And there's a sort of I don't know, it's not necessarily an old saying, but a thing where if everybody walks away slightly unhappy, it must be a good result.
It's a good. I remember that. You're right. You're right. Who is right? Everyone is right.
Yeah. Now, and a lot of money can be spent on, sometimes very small things that grow up, that blow up and become large issues, when if the parties can sit down frankly and discuss them, particularly if one party is willing to accept that they may have some fault, then certainly they can come to an agreement, and certainly they can settle the matter between themselves without having to go to the court. And in fact, the courts prefer that. They penalise people in some respects for not accepting an offer to settle if they get less than that offer in the actual court case. So in some respects, not accepting an offer to settle can have an adverse effect on the person who rejects it in relation to the matter of costs.
Interesting, especially the court gives that priority. That total makes sense. Now, what is making an offer to settle, and also sometimes it gets confused. Especially those
Yeah,
people who are not the legal hat. They don't wear a legal hat, and
sure.
normal people. What is making an offer to settle? Would that Are we talking big numbers here? Are we talking very
Yeah.
little? Or yeah, please.
So what you'll find is that sometimes the person who has been wronged, and I mean I use that term loosely, but sometimes the person who has been wronged will say, look, I'm on a commercial basis. If you pay me this amount, which is potentially less than what I think I'm entitled to, then we can settle this dispute. So people will enter into a settlement and enter into the settlement discussions. The idea is that it's going to cost you more to go to court. The end result is not necessarily going to be what you think it is. So therefore, why don't we make an offer on what we would term a commercial basis to settle the matter? So what does that look like? That depends on the parties. It depends on the position of the individuals or the companies or the opponents, I suppose, and it depends on what they are prepared to accept.
Absolutely. I think it's also not just about making an offer, but when you look on other side of the other party, so what do you do? Do you accept the offer, or what
Yeah.
happens if I don't accept the offer? So I'm
Well,
curious to know a little bit on that, please.
that's where life gets, I think, gets interesting, and I have to be careful here because this can sound very confusing. So the offers that are made in a litigation, offers are made on what's called a without prejudice basis, and that means that those offers are not disclosed to the court during the course of the litigation, but can be relied upon in the question of costs. Now, there's a general presumption that the person who is successful in litigation, that costs will follow the event. So if you're successful, you get your costs on what we call a standard basis. The standard basis is effectively was described to me once as like a Medicare schedule. So you don't get the full amount back. Now, if for example a offer to settle is made by a party, and that offer is then rejected by the other side. So hypothetically, let's just say that I put in an offer to settle this matter for $500. Hypothetically,
Mm-hmm, mm-hmm.
um, you then say no, I don't accept that offer. I think I can get more. I'm going to court. Now, you go to court and you get $400. So you've got less than what I offered you. But
Mm.
in that particular instance, the court will penalise you for not accepting my offer. So the other way
Even
that
penalized, real penalized.
so they will penalise you in relation to costs. So they will effectively allow part of the proceedings to be done on an cost to be provided on an indemnity basis, which is effectively almost full costs. So the court will look to try and penalise a person because if you had have accepted the offer, you would have got more, but you didn't accept the offer. So therefore, I'm entitled to my costs in relation to that on a different basis. So an indemnity basis rather than a standard basis. This all gets very, very confusing. I understand that, and it's best at the time to sit down with your lawyer and go through the various scenarios. It's impossible to explain them all right now, but in each individual circumstance, there will be a particular, I suppose, scenario that may play out, and it's important to understand what those scenarios mean. Which is why making an offer to settle a matter is a very big and important step, but rejecting an offer out of hand is also an extremely big step, and those decisions can have consequences.
Interesting. Now, that's something very, very, certainly this is a great value for our viewers, because we only talk about making an offer and don't really understand about accepting the offer, or what the consequences are. And thank you,
Yeah.
Len. I think that is really good insight. And obviously, especially when you have to pay back, that's very interesting that you say that.
It's important, though, that each individual circumstance is different. So it's important that you sit down and you map it out with your legal representatives, and you understand what the consequences of of making an offer could be. I mean, the other side of that particular story is that when you make an offer to settle, you must then be prepared. It must be genuine. You must be prepared to have that offer accepted. So, if I say, look, I want to settle this matter for $500, but I mean, I don't really want $500 because it's worth $5 million. Yeah, if you turn around and say, okay, I'll accept the $500, and I go, oh, hang on, I'm withdrawing that. That has consequences too. Okay. So you need to be prepared to if you're going to make an offer to settle a matter, you then need to be prepared to follow through with that offer.
Follow through. And just on that note, just curious, then if they accept an offer, then will that finalize? I mean, once the two parties are happy, okay, let's get in $500 in this scenario. Yeah. Then will it did that finalize? Will that finalize the dispute?
Yes. Well, generally, so I mean, you would generally suggest that the offer is made as full and final settlement of the matter. And then, there will be, on most occasions, the parties will then want to put that together in a deed of settlement. So the deed will say, this is the broad circumstances of the dispute. These are the terms that the dispute has been agreed it will be resolved upon. This is the amount that will be paid, and this is how the amount will be paid. So it could be, I will pay you $100 today, and every 7 days after that, I will pay you $100 until such time as the debt's paid off. So people will generally want to put that into a document and sign it into a deed, and then following that, obviously, there will generally be an agreement that if the matter is being litigated, that the parties sign a discontinuance and lodge that with the court, saying that the matter's been settled.
That's great. So pretty much there is a whole follow-up process right there.
Yeah, just a formalization process.
Formalize. Yeah. Now that's great, Len. I think that's very clear to our viewers right there. But if there's any specific questions you have for any of the projects or business matters, feel free to email to Len and his team. And obviously, what would be the best way for our viewers to get in touch with you, Len, please?
Okay, so there's a number of ways. Number one is 1300 at legal, our telephone number. That number, it works up the eastern seaboard. We also can be contacted via email at info@beckerwatt.com.au, and of course on our website there are the contact forms on there, and that's www.beckerwatt.com.au.
Beautiful. Thank you so much, Len. So I think that's very clear to our viewers, and definitely if you have a specific question, feel free to just call at 1300 at legal. Any final thoughts in this matter, settling a dispute, Len?
I think that it's always a good idea, if you can, to take control of the dispute yourself. I think that it's important that you don't give over that ability to somebody else. So allowing the court to decide your dispute may not get you the result that you want, and you can spend an awful lot of money to get to that point. I think it's always appropriate to consider whether or not you want to continue with the dispute, and whether or not it's commercially viable to. And it's important to have good and appropriate legal advice from your legal advisor to actually step through the scenarios to make sure that you are keeping on, I suppose, making sure that you don't create a bigger problem for yourself. But I suppose the big advice is try not to give that power away. Try and keep that power for yourself. Settle the dispute on your own terms if you can.
Beautiful. Now that's a great advice, Len. Definitely. And as a trusted legal advisor, you and your team are dedicated and focused, helping clients not just just focusing on a legal solutions, but really that business matters, and trying to help them where you can. So that's great. Thank you once again, Len.
Thank you, Prabhu. It's always a pleasure.
Yeah, thank you.
See you
Thank
later.
you, guys. I hope you enjoyed the show. By the way, if you like this, feel free to give us a thumbs up, comments, and share this. And tag to any of your audience so it can reach out. If there's any specific questions, feel free to just jump in and follow. Don't forget to follow us on YouTube at Talking Legal. Thanks again. We'll see you in the next